Hi, welcome everybody that is here live with us on Zoom or maybe that is watching later on the STAMP YouTube page. My name is Zach Mundy and I am the director of the Graduate Student Legal Aid Office. And we're here as part of our GRadulting workshop series where we provide weekly workshops on legal topics and legally tangential topics. Today we are lucky to have Jeremy Rachlin, who is a partner at Bulman, Dunie, Burke, and Feld, which is a law firm here in Maryland. And he is going to tell us why it's never too early to start planning for your eventual demise, is the sort of, friendly way to put it maybe, or the way that a Bond villain would put it. But he's going to talk to you about wills and estate planning and everything you can start doing now in your 20s, 30s, at the time you are a graduate student. We're very grateful for him to be donating his time to us today. If you have any questions throughout, just put them in the chat. If you want to make sure or hide any sort of personal information, just send it directly to myself or Simone. We both have GLAO in our name, and we can moderate them and forward them to Jeremy. We'll probably be doing most of the questions at the end, but feel free to send along any questions you have. And with that, I will hand it off to Jeremy. Thank you for being here, Jeremy.
Of course. Thank you, Zachariah, and thank you guys for having me. It's great to be here. I myself am a proud Terp. I graduated from College Park back in 2002 now, and I was a psychology major on campus. Knew many graduate students. I was an intern in a lab on campus, knew many graduate students in that context, and it's a pleasure to be here. I practice in the world of everything estates. Estate planning, which is helping folks just kind of understand what the concepts are to prepare for the unexpected. And then, of course, estate administration, helping families wind up the affairs after a loved one has passed away. And yes, from time to time, I also go to court and do estate litigation when there are fights over money. But today, I'm really happy to be here to talk to you guys about what are the essential elements of an estate plan? And we'll talk about it in a minute, but it's not just a will. There's a whole lot of other components of an estate plan that are particularly important to everybody, young, old, rich, poor. It doesn't matter. Having a fundamental set of very basic documents in order can provide really important protection to you and your family. I'm going to be talking about those kind of basic elements of every estate plan today. I'm going to be talking about some issues relating to inheritance and taxes. There were a few questions that were received actually before the presentation that tailored some things to those questions. And yes, if you do have questions, I love to tackle questions at the end. I generally, oftentimes, I've given some variation of this presentation with some degree of frequency. Lots of questions that I get, lots of different questions. And I always do invite folks that, I know that sometimes there can be sensitive questions that folks in a Zoom setting don't necessarily want everybody else to know it came from this particular person. So that's why if you have a question that you prefer the whole audience not to see has come from you, you can feel free to send it to Simone or Zachariah directly in the chat, and then they'll forward it or they'll moderate it on to me. I do have slides today, a handful of slides I'm going to share in a moment with a slideshow presentation. I'm happy to make the slides available afterwards so they can be emailed out. And with that, I'm going to share my screen. All right. Okay. So according to Zoom, it says I'm screen sharing and participants can now see my application, my screen, so that's a good thing. So yes, what is an estate plan and why do I need one even if I'm young? Well, I want to start by seizing on something that Zachariah said about wills. Early on, a few minutes ago, he mentioned wills and planning for your demise. And what I talk to folks about, what I talk to every client about at the outset is estate planning isn't just planning for your demise. It's a big part of estate planning, but there's really two components of estate planning. The first element of estate planning is not necessarily for your demise, but for your incapacity. If you become ill, if you're incapacitated temporarily or permanently, how can your household status quo be maintained? Who can make medical decisions for you? Who can engage in financial transactions on your behalf? This is while you're alive, but you need help. That's one element of estate planning. Now, of course, the second element of estate planning is planning for your demise, post-death planning. So who will inherit? On what conditions will they inherit? If you have minor children, who will be appointed as guardian, and who's in charge of all these different processes? And this is particularly really important for me. I'm married. I have a 12-year-old daughter, so I'm not particularly young, but I'm not particularly old. But these things do start to resonate as soon as you start to think about that adulting component. Really, these sorts of things need to be considered. So I'm going to start today by talking about that incapacity planning piece. Then we'll talk about post-death planning, and then we'll talk a little bit about taxes, and then answer some common mistakes, and then answer questions. So first up, the first core document of every estate plan is a healthcare power of attorney. It's also known as an advance medical directive or a living will. This is a critical document. This is the document that appoints another individual with the requisite legal authority to make medical decisions for you when you can't speak for yourself. Conceptualize a situation where you're in the hospital and you're unconscious and doctors need to get consent to treatment. Who do they talk to? Who has the legal authority to speak for you? That's governed by this document. It's an advanced medical directive. It empowers another individual to make those decisions for you and speak for you when you can't speak for yourself. It also contains a HIPAA release because for the agent while they're acting, for the healthcare surrogate, while they're acting as your healthcare surrogate, because of course, if we're going to trust or deputize a healthcare surrogate to act for us, we need to make sure that they have the requisite legal or they have the requisite information to make knowing decisions. So, what sorts of decisions might your healthcare surrogate make under this document? Really, anything that you would make when you speak to a doctor, anything from medical intervention, surgery, placement, rehabilitation placement, and even up to and including end-of-life decisions. Those are the sorts of decisions that a healthcare surrogate might make. Who should I appoint? This is really kind of obviously a very personal question. Nearly all of my clients who are married appoint their spouse first in line. But as you might be able to see from kind of the fuzzy image on the left-hand side, when we prepare these documents, and in fact, the state forms for these documents allow you to appoint at kind of a chain of command, if you will. So an initial healthcare surrogate, and then a backup if that initial can't be reached, and then sometimes even a second backup. So, if you are married, the easy question is, okay, well, my spouse will serve. But what about backups to your spouse? So who should you appoint? What I encourage folks to think about is who can, these documents are never going to be used, never going to see the light of day on a good day. These documents are going to be used, in a very, very, very traumatic, bad, emotionally charged situation. So I recommend to my clients that you think about who's calm under pressure, who knows and shares your values, who can communicate well. It doesn't necessarily need to be like someone who has particular knowledge of medicine, but that can't hurt a lot of times if somebody has like a doctor or a nurse in their life. That's a good person to appoint. But those are the sorts of considerations when we're thinking about who should you appoint. Obviously, it's a very personal decision, but I'm always recommending somebody who can communicate well under pressure, and that's the most important thing. Now, can you have co-healthcare surrogates, and should you have co-healthcare surrogates? The answer is yes, you can, and maybe you should, maybe you shouldn't. This becomes, this is more of an issue for clients of mine who have more than one adult child who they want to name as a healthcare surrogate, or clients who might be younger who have parents who they want to name as co-healthcare surrogate. So you can have co-healthcare surrogates, basically, but that can be treated as an either or proposition, meaning either of them can act without consulting the other, or it can be treated as a unanimous proposition, which means that both of them have to agree. If you were going to have co-healthcare surrogates, I can't advise this enough, avoid the unanimous approach. Again, documents not being used in a really great time. The last thing that your family is going to want, the last thing the doctors are going to want, is to have to round up more than one person, kind of get green lights from multiple different people. It's just, and furthermore, when you require unanimity, what you invite a situation where there's disagreement and deadlock, and in that situation, this document is basically not worth the paper that it's written on. So, to the extent that people want to have co-healthcare surrogates, I do recommend it being either or proposition, but I also recommend there being some very real thought in terms of, can those two folks who you named communicate very well with each other? Are they comfortable with each other? Is there any possibility that one will be hurt or worse, feel like they want to make some legal challenge if they're not consulted just because they're named and they get to the hospital second? So, in all candor, most of the time I counsel my clients to take that chain of command approach, first in line, second in line, third in line. But folks can have co-healthcare surrogates, and it's a decision that's right for some people. Who should you give a copy to? Good question. This document is an important document for a primary care physician to have amongst your medical records. With the amount of information sharing in the healthcare industry, most of the time, if you are rushed to the hospital, for example, and even if you can barely speak, if they're able to ascertain who a primary care physician is, if this is in your medical records with your primary care physician, they can pull this at the hospital. So, once you complete one of these documents, it's a good idea to have it on file with a primary care physician. Another thing I want to point out, and it's not on my bullet points, but these documents, every document I'm talking about today, can be amended later in life. So it's not like if you make a healthcare power of attorney at age 25, you're stuck with that document at age 75. You can create later documents which supersede, which take the place of this document, which is very important over time. Because in our life cycles, oftentimes we start with a parent who's perhaps the most best fit for this healthcare surrogate role. Then maybe we get married and a spouse is the most important person. Then maybe we have kids and those kids grow. And those kids, once they hit an age of maturity, could be included in the chain of command. So this document and the others I'm going to talk about today can be updated over time, but it's kind of that pillar of an essential estate plan. What if I don't have it? So there are some safety nets in Maryland and DC law, and I say Maryland and DC because I am licensed in those two states, those two jurisdictions, I should say, and so I'm legally only allowed to opine as to that or discuss those. If you don't have a healthcare power of attorney advanced medical directive, there are some healthcare surrogacy laws that permit a spouse, if there's a marriage, or parents, or children, to make certain healthcare decisions. Now, it's not as extensive as the rights that are granted in an advanced medical directive, but at least there's something. So for folks who don't have one, there is some safety net there, which is different from the next document that I'm going to talk about, which is the financial power of attorney. So last document that we just talked about, healthcare decision-making. But when we're sick, our bills and obligations don't stop. Today's tax day. tax returns have to be filed. If you're incapacitated, you probably need someone to put in a claim on health insurance. There might be other rights that you're entitled to, disability rights, disability insurance, governmental benefits. Somebody's going to have to pay those doctors. So somebody's going to potentially have to reach into your bank accounts and ensure that your bills get paid. And that is all done by an agent who's acting under a Maryland financial power of attorney. DC also has its own statutory financial power of attorney. Both Maryland and DC have those forms. So this document, as I mentioned, this is the companion document to the healthcare power of attorney, and it authorizes an individual to act for you with respect to everything that directly and indirectly relates to your financial affairs. Sorts of financial transactions, as I said, everything from taxes, insurance, bank accounts, disability claims. I like to tell folks initiating litigation on your behalf. If the reason why you're disabled is you got run off the road by an Amazon Prime truck, well, your family might have just hit a payday, and your financial power of attorney can pursue litigation on your behalf while you're incapacitated. Now, who should I appoint? Can I have co-agents? Should I have co-agents? So, to be very clear, you do not have to name the same person in both your healthcare document and your financial document. Now, commonly, for my married clients, the spouse is named in both, but the backup agents can be different. Or for unmarried individuals, they can have completely different individuals, or they can have the same individuals. You play to people's strengths. If they're unquestionably, trustworthy with money and financial matters, they're a good fit for this. Now, can I have co-agents? Should I have co-agents? Very much the same analysis I just talked about on the healthcare document. You can have co-agents. You can require unanimous action, or you can permit unilateral action. And I'm very much disinclined to encourage folks to do unanimous. Big believer, and if you are going to take that leap of faith and co-agents, allow either of them to act. But do bear in mind that this document's going to be presented to banks and financial institutions, and they hate financial powers of attorney. They're very, 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 because in their perspective, they're essentially letting somebody who potentially has no claim on an account, they're giving somebody who has no claim on an account access to an account. So they're automatically suspicious, and they don't make it necessarily easy to use this document. So I'm a big believer, path of least resistance, document's not going to be used on a good day. So again, big believer in a chain of command approach. Now, what if I don't have one? A few moments ago, I talked about how there is some safety net in the law that's built in if you don't have an advanced medical directive. There are some surrogacy laws that are out there that permit folks to make healthcare decisions for you if you don't have an advanced medical directive. Not necessarily the case for finances. If you are on a joint account with a spouse or somebody else, well, that joint account holder can access that account, but there are certain things that are personal to you, such as signing tax returns, such as your retirement, such as making claims on insurance, and many, many, many other things. If you don't have a financial power of attorney and somebody needs to transact in your resources or initiate claims on your behalf, that will require the loved one to get an order of guardianship over your property, which is a court proceeding. It's not an easy court proceeding. It's not a quick court proceeding. And it's something that can be totally avoided by this simple document. Guardianship is only available under Maryland law and DC law if there's no less restrictive way to manage that person's finances. This, a financial power of attorney, is a less restrictive method than a guardianship. So this very simple document can save your loved ones a world of angst and a lot of money if something happens to you. One final thing I talk about, because it comes up a lot when I'm dealing with my clients who have lost a loved one, is a power of attorney ceases to have any legal authority, or a power of attorney ceases to have any legal effect, I should say, when you die. When you die, when you take your last breath, the person who has authority over your finances is the executor of your estate, which is somebody who's nominated in a will or can be appointed under Maryland law if you don't have a will, and I'll get there. But so, a lot of times people have a power of attorney for a loved one and they try and continue to use it after their loved one dies. And it's like, no, that power of attorney, it's like, there's like the magical, like poof, as soon as you take your last breath, your power of attorney ceases to have any legal effect. So I like to put that out there just because it's a common misperception that arises. All right. Now, I'm going to focus a little bit on, just kind of Maryland, because we are in Maryland, in University of Maryland, but basics of a will. So what are the required formalities for a will to be signed? What are the elements of each will? And just what are some things to know about a will? Common misperception that a will needs to be notarized. Not in Maryland, and actually not in the District of Columbia either. A will doesn't need to be notarized. What are the requirements of a will? That will needs to be in writing. So verbal wills, not allowed. Handwritten will, okay. Typewritten will, probably better. But that will must be signed in the presence of 2 adult witnesses. And here's the rub. Everybody needs to see each other sign. So the witnesses need to see each other sign and the testator. The testator is the person that makes the will, and the testator needs to see the witnesses sign. So in my office, when we have signing appointments, big round table, document goes around the table, signed by the testator, signed by the witnesses, everybody sees each other sign. Now, something that's important to know is best practice in Maryland is for the witnesses to not be a beneficiary under the will, to not be a family member and not be a beneficiary. But that's merely a best practice. In the District of Columbia, if a beneficiary witnesses a will, that beneficiary is not allowed to inherit under the will. So it's a really big stick. So just best practice, if you're going to make a will, don't have a family member, don't have a beneficiary be a witness. Notary, 2 adult witnesses. Honest to goodness, UPS stores have notaries and witnesses. Maryland will, got to be writing, signed in the presence of 2 adult witnesses. Now, what's in each will? Well, we have kind of, who is going to inherit? And generally speaking, in wills, we break things out between your tangible personal property and your monetary assets. Tangible personal property, the best way to describe it is if your apartment or your house or whatever, wherever you live, gets picked up, shaken out, the things that fall out, that's your tangible personal property. The things that fall out that's not cash, that's your tangible personal property. And everything else is what's called residue or monetary assets. So we generally, in our wills, we break out tangible personal property and monetary assets and who will inherit, and particularly with monetary assets, what shares those are. So is it going to be like equal shares, as many children who you have? Is it a spouse? What that looks like. You can also put into a will what's called specific bequests. So if there's one particular family heirloom that a child or a sibling or a parent or somebody would really, really, really want, you can put specific bequests in your will and then kind of have the blanket, then everything else, all my other tangible personal property will go to person Y. Same thing with monetary assets. You can make a specific bequest of a home, for example, and then kind of split everything else up. But that's included in the will. The will discusses who will inherit and in what proportions. Now, something that is probably the most important issue to me and to many of my clients with minor children is your will contains a guardianship point. This is the provision that basically says if I have a child and I die and at the time of my death, there are no parents who can parent. So there's no one who has parental rights at that point. This is the person who I would want to have care and custody, basically be guardian of my child or children. Now, bear in mind, that will still be subject to a court process. The person who's nominated as the guardian within a will is still going to have to go to court and get a guardianship order to basically give them legal custody over the child. But that guardianship appointment is essentially a super priority once that court proceeding is started. The court essentially, if there's a guardianship nominated, if there's a guardian that's nominated, the court generally has to find evidence why that guardian is unfit to serve in order to trump the desires, the nomination that's made by the parent within the will. So that's where we deal with guardianship, is within a will. Now, the last essential element of each will is the nomination of an executor. In Maryland, we call it, in DC for that matter, we call it the personal representative. This is the person who basically this is the person who runs the show. This is the person who is in charge of winding up all of your affairs, filing final tax returns, dealing with any debts and expenses. I mean, very seldomly does someone pass away on the first of a month with a fully paid off credit card and the bills just stop. I mean, things continue to come in. So the personal representative, that they have the task of winding up your affairs and then ultimately distributing the assets in your will as the will requires. And the assets which pass under a will are administered under the supervision of a probate court. And so the personal representative basically has to file accountings with the probate court, and beneficiaries get copies of those, but that's kind of the oversight of the process. Now, one of the things that's very important to people, particularly I think grad students and younger clients who have many years ahead of them and who may well move, is that your will can move. For a Maryland resident, for example, so long as you are a Maryland resident at the time you sign your will, and your will is executed in conformity with the laws of the state of Maryland. So in writing, signed in the presence of two adult witnesses, and everybody sees each other sign, that will would be recognized in any U.S. state or territory. Same actually holds true for those powers of attorney. And that's a legal doctrine called comity. Basically has to do with the fact that because we're a big country with lots of different states and territories and lots of different laws, which with the requirements of these documents, we don't want somebody to live in fear that I've moved and suddenly my will is invalid. So your will does remain valid if you move jurisdictions. Now, one piece that is important is that if you have foreign property, and meaning assets like bank accounts in another country, particularly real estate in another country, you may need a will that's executed in accordance with the laws of that particular country. Not every country recognizes an American will, and that's a two-way street. The United States doesn't always recognize wills from other countries. So if you have property in, I'm just going to pull a random country, France, for example, you own real estate in France and you die. Well, and then your loved ones need to, change title from your estate, retitle the real estate. Under French law, they may or may not give recognition to what your will says in terms of who should inherit this property. So, that is always, if you have real estate or monetary assets in another country, you absolutely should check in with an attorney, an estate planning attorney or an estate attorney in that foreign country to make sure that your United States will can govern the disposition of those foreign-based assets. All right. So what if I don't have a will? And this is called intestacy. Intestacy is a term for, if you don't have a will. Well, here's the trick. Everyone actually has a will. The question is whether it's the will that you signed and that reflects your wishes, or whether it's the will that you haven't signed, but that's the default laws of intestacy which govern the disposition of your assets. And this is what I mean by that. If you don't have a will, the laws of intestacy exist as a default. Somebody has to inherit your property. If you don't have a will, every state has default laws which govern who will inherit your property and in what shares. And it may well be totally inconsistent with what you would want. Here's a good example. In Maryland, the law of intestacy says that if you have a surviving child and you die, so you're married with a child, most folks say, well, I would want my spouse to inherit everything. That's not what the law of intestacy says. The law of intestacy splits the estate between spouse and children if you don't have a will. I've had that come up a handful of times, unfortunately, in years, and that is it's a really, really, really hard and harsh surprise for folks. So, everyone has a will, because if you don't have a will that you have signed that sets forth your wishes, state of Maryland or the District of Columbia or whatever state you're living in at that time has its own default laws in terms of who will inherit. Now, so I've talked about that. And then let's see here. Who would serve as the executor of your estate if you don't have a will? Well, similarly to how intestacy fills in the blanks in terms of who would inherit, there are also provisions that are kind of default pecking order for who would be the personal representative of your estate if you don't have a will. Typically, that starts with the surviving spouse, then proceeds down to any adult children, then next would go to parents, then next would go to siblings, and so on, just kind of as we get further and further in relation to you. But that's kind of the default. Every state has these default laws that apply if you don't have a will. So what I tell folks is having, just kind of like how having a financial power of attorney is a very easy way to avoid your family from having to go through that guardianship proceeding. A will, even a very simple will, is a very basic way to keep control of the process after you pass away. And of course, if you have minor children and you haven't made a guardianship election within your will, then there are also default laws of guardianship in terms of who would be a minor child's guardian. All right, death and taxes. So I'm gonna take a sip of coffee real quick. So there were a handful of questions that I got before the presentation about taxes and kind of the interplay between death and tax, the two certainties. So first of all, something that is that there can be a big difference here between citizenship and permanent residence, for that matter. Citizenship and U.S. citizens and permanent residents versus non-citizen, non-permanent residents. So let's start with U.S. citizens and U.S. permanent residents. Generally speaking, the inheritance that a U.S. citizen or permanent resident receives is not subject to tax. It's not treated as taxable income. It's not subject to an income tax. Now, income that's later earned is subject to tax. So what do I mean by that? If I'm a U.S. citizen, if I inherit $1 million, that $1 million is not taxable income. I do not have to pay taxes on that $1 million. Now, over time, if I properly invest that $1 million, that $1 million will generate income, it will generate interest, it will kick off dividends. That later income that's earned by that $1 million will be subject to tax. But that $1 million core that I have inherited is not subject to tax. That blows people away. I can't tell you how many times I'm probating in the state and people are like, they're bracing for the bad news of like having to like, do some withholding for the inheritance or, estimated tax for the inheritance they're about to receive. And I get to be the bearer of sometimes good news in the time of bad news and tell them, well, you're not going to actually owe tax on this. Now, this could not be more different than how most other countries handle this. I have an estate right now where the beneficiaries are German. And in Germany, the German government is taxing very significantly the inheritance that is received by each German beneficiary. So this is a very, I'd say, US specific concept that inherited wealth, inherited assets are not subject to tax because most other countries do treat inherited wealth as not necessarily income, but at least as exposed to tax. So it's a very, very, very important concept. The other important concept is for non-US citizens and non-permanent residents who die in the United States. So the IRS looks at it from the perspective of, well, you haven't been exposed to income tax, you haven't necessarily paid into the pot. So you died here in the United States and you're a non-citizen, non-permanent resident, we're going to assess tax now. And we're going to assess tax on all of your assets in excess of $60,000. And we're going to assess a tax on that at 40%. A massive tax. It's called a state tax. This is an area where US citizens and permanent residents are treated very differently than non-US citizens. US citizens, that estate tax doesn't get triggered until you're north of just about $13 million in assets. But for non-US citizens, non-permanent residents who die in the United States, any assets over $60,000 that are located in the US are exposed to estate tax that can be as high as 40%. So just an important concept and one that was asked prior to the presentation. I don't normally necessarily include these concepts in a presentation, but I'm happy to get the questions beforehand and hopefully that answers some questions that folks had. If you have more, please drop them in the chat. So I'm going to close with just some common mistakes that folks make in their estate planning. So first of all, I recommend that all of my clients make what I call a cheat sheet for the financial agent who's acting under the power of attorney and the personal representative or the executor. Basically, if somebody has to parachute into your life, either because you're ill or because you passed away, and they need to marshal your financial assets and make sure that those bills continue to get paid, make sure that that the trains continue to run on the tracks. What sorts of information might that person need? I'd suggest they need information about bank accounts, liabilities, loan payments that come out, how much and when and what account. You don't necessarily need to talk about balances of bank accounts, but like, where do you maintain the bank account? What kind of account is it? Is it a checking account, savings account? What's the account number? What sorts of life insurance policies, if any, do you have? All of your financial holdings, but I recommend honestly going so far as email password, iPhone password. This day and age, if you're sick and someone tries to log into an account, and they're doing it from an unfamiliar iPad or computer, first thing that's going to happen is, the institution is going to say, we don't recognize this device. We have texted the code to such and such phone. Well, they need the code to your phone to get the code that's needed to log into the account. So really, kind of part of estate planning is having this cheat sheet along with your documents. Failing to review documents every few years. Listen, once you create these documents, congratulations, good job. Good job. But every few years, I do recommend dusting these things off and reviewing them. And really, what are you reviewing? Maybe the same things my wife and I reviewed a couple years ago, which is really, are the people that we've named in this document still the best people to fill those roles. Are they still physically located around us or physically in the US or close by? Are they still the right people? As I said earlier, when we name parents, parents can age. And sometimes they're no longer people who, you love them, but you're like, God, if I'm in an accident, the last person who would think rationally and calmly now is mom or dad. And that's a hard reality, but sometimes it is the reality. So, I do recommend to folks that they review these documents every few years. Not thinking about beneficiary designations that you have on file. So, a beneficiary designation is a document that essentially takes the place of a will with respect to certain kinds of assets, chief among them being insurance policies and retirement accounts. When you start with an employer or you take out a policy of life insurance, when you're doing that onboarding, oftentimes there's a beneficiary designation form and you fill out a beneficiary, and the beneficiary, you have to put the person's name and social security number. And the purpose of that form is to say who will inherit that account or that asset when you die, or if you die, or when you die. Well, I have had folks who have completed those forms, gotten married, forgotten to update the forms, and died. Mom and dad are still on the form, brother or sister is still on the form. And notwithstanding the goal that a spouse inherit everything, and even a will that says a spouse inherit everything, an asset that has a beneficiary designation on it is governed by that designation and not the will. So think about your assets and be very conscious about beneficiary designations that you have on file. Next up, get asked all the time, can't I use, LegalZoom, ChatGPT, AI, whatever it might be? I'm a realist. I'm also a big pragmatist. I'm a big believer in not making things overly complicated and overly expensive. And I will be the first to tell you that, look, state forms that are available on here in Maryland, our financial power of attorney and our advanced medical director are pretty easy to find online on the Attorney General's website. No problem downloading those forms and filling them out and getting witnesses and notaries. And hey, that's a great start. Great start. Big believer in using those forms. Not at all a big believer in using AI or any of these document assembly softwares to create a will. Quite honestly, there's just as good as this AI is, I continue to run into massive problems. We call them DIY wills, do-it-yourself wills, where we have inconsistent provisions, where we have incomplete wills. And the problem is people who don't know what they're doing don't know what they're missing. So they think that the will has everything, but they don't either understand that they've created an inconsistency or they don't see that there's something missing. So look, I am a big believer in having a will prepared by a licensed attorney. POAs, we prepare POAs just as part of our standard estate plan. But POAs are something, you can, if you leave this presentation today and say, my God, I don't know that I'm ready for a will, but I'm ready to do POAs, go get them online. Fine, go use the state forms. Last thing is just kind of failing to take into account state-specific and country-specific rules regarding taxes. As I said a few minutes ago, there are country-specific rules which govern tax, which govern inheritance, and there are some state-specific rules. The laws of Maryland and the laws of DC are different than the laws of Pennsylvania, for example. Pennsylvania does assess some inheritance tax on estates that Maryland and DC doesn't, or Maryland and DC don't, I should say. Good grammar. So this is also someplace where it can be helpful as you're doing a will to chat with a lawyer and make sure that your estate plan takes into account the taxes and the rules that are specific to the state that you live in, the state that a beneficiary lives in, and the country that a beneficiary lives in. So that is all I got. I'm happy to answer any questions. I have my email on this slide. My phone number's on this slide. I mean this, I'm happy to be a resource. If you have questions that hit you, or that you go home and talk to someone at home and want to run by me, email me. I'm happy to answer. Email is probably the easiest way to reach me. And with that, I'm going to stop my screen share and be happy to tackle any questions that have come up.
Thank you, Jeremy. That was very informative. One of the reasons I love these workshops is, even as an attorney myself, it's always nice to learn new things, as well as sort of recap some of the things that I may have forgotten over the years. We do have a few questions in the chat that I'm going to run through. The most recent one was just asking for clarification on beneficiary designations taking precedent before or over the will. And if you could just give a little bit more detail on that.
Absolutely. So beneficiary designations do trump a will. Whatever your will says, a beneficiary designation, and this is the federal law, it's the alphabets of the federal laws, but the big one that applies here is called ERISA, E-R-I-S-A, Employee Retirement Income Savings Act. But basically, what that means is that and I have another one that comes up. This comes up commonly in the event of divorce, where someone has gotten remarried, never updated a beneficiary designation from their first spouse. The person dies, first spouse, designated beneficiary, and honestly, the only obligation for the insurance company that has the beneficiary designation on file, or the institution that has to look down, say, yep, this is a valid beneficiary designation. It was signed. This is the person that's designated. You satisfactorily proven yourself. Here you go. So absolutely, beneficiary designations trump wills. And actually, so for many clients, there are very few assets that sometimes pass under wills. If you're really only, if you have insurance and retirement and brokerage and all of those assets have beneficiary designations, sometimes it's really the beneficiary designations that transfer the majority of wealth.
Great. Do you want to touch on that last question? So I know that you mentioned the Maryland Attorney General website for the advance directive and power of attorney. They have forms for the state of Maryland. Do you know if Virginia similarly has templates?
Oh, goodness gracious. I'll be honest, and I apologize. I don't know if Virginia has their forms available online, but I will tell you that both Maryland and DC, their forms are available through the Office of Attorney General, because it's the Office of Attorney General that's in charge of basically all it's a real legal term, the legal stuff. So I would imagine that if Virginia documents, if Virginia forms are available online, that they would be found by somewhere on the Virginia Attorney General's website. I apologize. I don't practice in Virginia, so I don't know the answer to that question.
Oh, it meant help finding an attorney in Virginia.
Help finding an attorney in Virginia. Email me offline. I can get you. I can give you some referrals. Absolutely.
Perfect. One other question. Have you found any? They asked about the Maryland state forms and if they are sort of sufficient, and you touched on that. But are there any sort of common scenarios where you wouldn't recommend those forms, or any deficiencies that they have?
Not really. I mean, I will tell you that the Maryland forms really are a creature of the legislature, and really one of the primary voices in the legislature is the Maryland State Bar Association Estate and Trust section. So there actually are about to be changes to the power of attorney form as a result of this past legislative session, and the Maryland Estate and Trust attorneys, the bar, had a lot of say in those changes. So really, the forms are I see people who have kind of, for lack of a better word, kind of cannibalized forms, made their own form, some of the LegalZoom forms, and these state-specific forms are not only created as a result of the bar and the attorneys and the legislature, kind of the collaboration, but most importantly, when they're actually used, they're recognized in the state of Maryland. So, for example, the bank and the student union on campus yes, a Florida power of attorney will be recognized, but it's not going to be as instant as like, okay, here's a Maryland form. We've seen these before.
Great. Wonderful. And so a couple other questions just popped in. Is it possible to bypass the parents of an underage child or children and designate the grandchildren as the beneficiary when they reach a certain age?
So absolutely. I mean, you can generally, so generally speaking, when we're talking beneficiary designations, and we're not talking a will here, but when we're talking about, well, really will too, because a will, you can specify, anybody who you want can inherit. Beneficiary designations, if you're married, most of the time, if you're designating somebody besides a spouse, they're going to want the spouse to actually sign off on the beneficiary designation because they just kind of have seen this playbook played out a couple of times before. But you can designate whomever you want. I have clients who designate grandchildren. The one thing to keep in mind is, so really two things to keep in mind when you're designating somebody besides spouse, children, spouse and children. Something called generation skipping tax. I don't want to get too far into the weeds, and it's such a huge number that it doesn't impact most people. In fact, it impacts very, very, very few people. But anything, and you may laugh when you hear this number, $12.9 million is the magic number here in 2023. You can give grandchildren, you can skip a generation and give up to $12.9 million. If somebody in the Zoom has more than $12.9 million, congratulations. And if you give more than that to grandchildren, that will trigger a tax. But otherwise, there's not going to be any generation skipping tax because you're below that number. One thing to kind of also keep in mind in Maryland, is specific to Maryland, not the law in DC, is Maryland actually does assess an inheritance tax for what we call non-lineal descendants. So sometimes people want nieces or nephews, or aunts or uncles to inherit. And the state of Maryland assesses an inheritance tax. We're one of the few states that does that. And whether it's property that passes under a will or property that passes under a beneficiary designation, there would be inheritance tax assessed by the state of Maryland against nieces, nephews, friends, anybody that's not, a lineal descendant. So anybody that's not a parent, child, grandchild, sibling, inheritance tax exposed. I just talked way too much answering that question. I'm very sorry.
The more information, the better. We appreciate that. And it looks like the last question we have, unless another one pops up, is what do you do with the stubborn parent or grandparent unwilling to fill out these forms? Is there anything a family member can do to help?
No, you're hitting close to home. It's hard, right? I mean, it is hard as our parents age, and we see them start to age, and we can only control but so much. I occasionally have clients who will basically set up not quite an intervention, but clients who will basically set up an appointment for their parents, and I'll explain these documents to them, and I'll explain to them in kind of non-threatening terms, but why these documents are so important. And most importantly, what I try and stress is it's a way for you. A lot of times older folks feel like signing these documents is giving up control. And what I try and stress to them is it's actually keeping control. Because if you don't sign this document and then the courts get involved, there could be this whole universe of people who suddenly have a right to come in and make decisions who you would never want. So that's when I talk to folks about kind of the way to package this, if you will, for older, stubborn parents, and again, hitting close to home. It's a way to, that they can actually keep control. But, at the end of the day, the old saying, you can lead a horse to water, but you can't make that horse drink. It is up to mom and dad to sign those documents, and they nothing that you can do to really force the issue. See, there's one more question that came in.
Yeah, do you want to go ahead and take that?
Sure. And the question is, are there ways to exclude children's spouses from inheriting any assets? And the answer is very simply yes. Don't name a child's spouse in a will or as a beneficiary. And if you name child A and child B as the beneficiaries under a beneficiary designation or under a will, child A and child B are the ones who will inherit. It's not spouse of child A and spouse of child B. And now, that then, it becomes up to child A and child B whether to keep that money segregated. And of course, they use that money. I think most parents anticipate that a child will use that money for kind of the family good, pay for vacations, pay for college, pay for things of that nature. But, it's kind of up to the child who inherits to keep that asset segregated. If a child inherits and then kind of places that in a marital account, it becomes kind of marital property at that point. But I will tell you, in wills and trusts and everything else, I very, very, very seldomly mention spouses. Yeah, that's honestly. So the best way to protect it is for a child who inherits to inherit wealth and take that wealth and keep it in a segregated account that's obviously used for the good of the family, but not mixed with marital resources.
Great. We are extremely appreciative for Jeremy volunteering and dedicating his time to answer all these questions. It was a fantastic presentation. We are going to forward everybody his contact information as well as the slides that he used to present. And so if you have any other questions, feel free to reach out to Jeremy directly or reach out to us at the Graduate Legal Aid Office. This is our last GRadulting workshop of the semester. And so we just, as always, want to say good luck on your finals, your final projects, everything you have coming up. And just know that we are open year round. So even though the semester's ending, we will be here throughout the summer to answer any additional questions you have, whether it's about estate planning, simple things, simple estate planning questions. We don't do anything complex for you. It's more doing research and answering basic questions, but we can forward you to Jeremy when we do have something more complex. But we're here to help with whatever your legal issues are. And if we can't help, we're here to put you in contact with great attorneys and some of them TERP alumni like Jeremy here. So thank you everybody for attending, and we'll see you soon, hopefully.
Bye, everybody. Thank you for being here.